begin now. Welcome everyone. Tonight is my absolute pleasure to be the moderator of this new webinar on this series of webinars of the topic is the law in the Americas, are webinars in which we engage perspectives from the US and also Latin America about topics that are of common interest in the region. Tonight, I have the absolute pleasure to be the moderator of an exchange of views between two great scholars in the field of intellectual property law, who are going to talk about a very important issue right now concerning the IP rights of the COVID vaccines. On the one hand, we have Juan Fernando Cordova Marentes. He's the Dean and Professor of Law of the School of Law at the University of La Sabana. And on the other hand, we have Diego Chavalala, who is a professor at the University of Dayton School of Law. But before we begin, I just would like to say a couple of practical things. The first one is that there is room for questions at the end of both of the presentations, and for that purpose, I would like to encourage everyone to use the Q&A feature down in the screen of this Zoom. Also, we have tonight Annabelle, who is an interpreter, that we will perform the interpretation between Spanish and English-Spanish. And if you would like to connect to that one, please use the button at the end of the screen about interpretation. I'm going to say this in Spanish. En esta noche tenemos la posibilidad de tener traducción al castellano. Entonces, para tal fin, las personas que estén interesadas, por favor, presionen ese signo de traducción o interpretación que está en la parte de abajo del Zoom. And without any further matters, I would like to give the floor to Dean Strauss, who is the Dean of the University of Dayton School of Law, who would like to say some words for beginning this webinar. Thank you so much.
Thanks so much, Carlos. And I'm really, really pleased to be here tonight and to observe this. Of course, COVID has been such a difficult time for all of us. It's been a period where we've all, everywhere in the world, have experienced something very, very similar, which has really, I think, shown a lot about how united we are. And that is in terms of all of us being part of one human family. Everyone has vulnerability to COVID. But of course, it's not all completely equal because of vaccines and so forth. And that's going to be the very topic tonight. One of the things that's come out of COVID for us has been these type of seminars that we're able to do online. And this might be something that will really survive COVID for us. It's been a wonderful way to really build connections with our partner schools in Latin America. And among those partner schools, there's really no school that we feel more connected to than La Sabana in Colombia. So this is really just a wonderful opportunity to build these connections. Our partnership is still very early. It's all really come together in the last year. And it's my hope that we will have many, many more opportunities to connect over the coming months and coming years and just build an ever deeper partnership. So estoy muy contento para estar aquí hoy día y tengo mucho interés en oyendo que ustedes van a discutir. Y después de esto, vamos a empezar. Gracias.
Thank you so much, Dean Strauss. And now I would like to give the floor to Professor Juan Fernando Cordova, who will be the first speaker tonight. Please, Professor Cordova.
Thank you, Carlos. Thank you Dean Strauss, for all your presentation, introduction, and thanks to everybody here today in this webinar. I'm gonna share some images here. Let me start. And now, okay, I think you can see in this moment. Okay, last May, the United States government expressed its support for a possible suspension of intellectual property rights on vaccines against COVID-19. As you can see in this slide, Ambassador Catherine Tai stated that this is a global health crisis and the extraordinary circumstances of the COVID-19 pandemic call for extraordinary measures. The administration's continuous Ambassador Tai believes strongly in intellectual property protections, for example, patents, but in service of ending this pandemic, supports the waiver of those protections for COVID-19 vaccines. And later, she had in the communications from her office that as our vaccine supply for the American people is secure, the administration will continue to ramp up its efforts, working with private sector and all possible partners to expand vaccine manufacturing and distribution. It will also increase the raw materials needed to produce those vaccines. Maybe that was the picture or the photo last May. We all know that a booster dose will surely be required and that therefore billions of additional vaccines will need to be produced to apply to the world's population. Not only the past doses, billions of doses already apply to populations, all the people around the world, but an extra dose in order to booster all the protection against COVID-19. Unfortunately, the outlook is not good, especially in the poorest countries. And the lack of vaccination is directly affecting their economy recovery and, more importantly, to guarantee their life, health, and other human rights. As you can see in this photo, in this graph, this is the photo today, August the 18th. This is the photo of the vaccination, the share against COVID-19 in different countries of the world. As you can see, the lowest vaccination rates correspond to the poorest countries in Africa, Asia, and in some cases, Latin America. In the other graph, we can see, for example, Haiti, less than 1% of vaccination rate. Very similar in other African countries. In African countries, of course, Haiti in America. As a consequence of this close relationship between human rights and access to medicines and vaccines, different human rights organizations and courts have made statements so that intellectual property rights do not become an obstacle to accessing vaccines. This is the case, for example, of the Inter-American Court of Human Rights, with a declaration last year, in April of last year, at the very beginning of the pandemic. And is the case of the Inter-American Commission of Human Rights, with two resolutions or declaration resolutions, Resolution 1 of 2020 and Resolution 4 in April of 2020. But maybe the most complete or comprehensive resolution on this matter is resolution number 1 of 2021. In this resolution, you can read the following. Without prejudice of the reasonable compensation that this business and public research institutions deserve for the investments and research they have undertaken, given the magnitude of the pandemic and the danger it poses to global health, national and international intellectual property regimes must cease to be an obstacle preventing the production of safe and effective vaccines, guaranteeing universal and equitable access to them, as set forth in this resolution. It is therefore urgent for states to take measures necessary to add flexibility, and this word, this concept is very important in order to take advantage of IP tools to control all the pandemic, flexibility, and exceptions in those regimes where public health is at risk, along with other pertinent complementary measures. Specifically, this commission joins the call made by the special mandates of the UN Human Rights Council and other committees, and for example, from some provisions of the TRIPS agreement for vaccines and treatments for COVID-19 that some states have proposed to the World Trade Organizations, and it urges the states of the Americas to support the exemptions swift adoption. This declaration was in the same line that other declarations from countries like Brazil and South Africa last year. And that was the declaration that the United States make support in May of this year. But the commissions also add some thoughts about the intellectual property regimes in this time applicable nowadays in different parts of the world. With regard to intellectual property regimes, states are called upon to promote the exchange of information on development of vaccines and ensure that economic value and regulations do not pose obstacles to the acquisition of supplies, technologies, and vaccinations. The harm and public interest test described in paragraph 23 of the resolution of this same resolution 1 of 2021 must be applied when intellectual property, trade secrets, and the right of access to information are found to be in conflict. And this is a statement that is very common when we are in the front of intellectual property rights and other human rights like health, life, of course, and sometimes education, that maybe there is a conflict between all those rights, private economic rights and human rights. But I think that this apparent conflict can be solved with the use of different tools available in the IP regime and IP international treaties. For example, compulsory licensing and parallel importations, and maybe in some cases, the applications of waivers as was requested for these countries, Brazil, India, and South Africa. But what is compulsory licensing? This licensing occurs when a government allows someone else, enterprise, pharmaceutical producer, to produce a patented product or process without the consent of the owner, the holder of these rights, or plans to use the patent protected invention itself. It is one of the flexibilities, the key word, the flexibilities in the field of patent protection included in the WTO agreement on intellectual property that you know as the TRIPS agreement, the trade-related aspect of intellectual property rights in the Marrakesh Agreement or the WTO agreement. They are not new, this flexibility, the compulsory licenses, they can be used in any case. There is an very clear emergency, public health emergency, and it has been used in different moments in the past, for example, to help some countries to use all these patents, not only vaccines, but also some medicines to cure AIDS or other pandemics, other situations of public health around the world. They can be used in different countries according to their proper legislations applicable to intellectual property and to pharmaceuticals. Sometimes this flexibility, the compulsory license, is difficult to obtain from governments or national producers, domestic producers of pharmauticals. For example, in our country, there is a case of compulsory license that it takes more than 5 years to get this license to produce a medicine for hepatitis B. So sometimes it's difficult, but we think that this is the most flexible way to get the opportunity to produce in our countries, for example, in Colombia or other countries with low or middle income, to produce domestically all the vaccines we need nowadays to control all the COVID-19 pandemic. So we would like to explain some particularities of this compulsory license. For example, what is an emergency? If they need to prove an emergency to issue a license, a compulsory license, in order to control all the COVID-19 pandemic. There are some definitions on the Doha Declaration. The WTO agreement on intellectual property rights was complemented in 2001 by the Doha Declaration that allows all the countries, especially low-income countries, to use this flexibility in a very swift way, so they can, they don't have to prove a very, very dangerous emergency, but just a public health situation. And the possibility of the country or producers in the country to supply and to produce and supply the medicines needed to control all the public health situation. But this public license is not a waiver. They don't have to resign they don't have to let all the rights away. They can receive a payment, an adequate payment, in order to compensate all the research costs, all the distribution, all the money they invest on the medicine or the vaccine in this case. So there is an authority in every country that have to decide how much they have to pay in order to get a compulsory license. That is the reason why sometimes all the process of compulsory license is very difficult to obtain, because there are some differences between the price, not some, huge differences between the price the pharmaceutical company wants to recover and the price the country or the national producer wants to pay for this compulsory license and the possibility of producing the medicines in their own countries. That is the reason it can last several years, all the process to obtain finally the compulsory license. So in this moment, when we are debating if we need to waiver all the rights, it is a difficult question. It's maybe it's a difficult proposal, because they need to agree with all the countries or the majority of the countries that are present in the WTO. More than 164 countries are present or are members of the WTO. So for that reason, it's a better way to control all the pandemic of COVID-19 and to get some flexibilities and the possibility of produce locally the COVID-19 vaccines, doing or getting a compulsory license from the main pharmaceutical companies like Pfizer, Moderna, and other producers around the world. So the answer to the pandemic, or the answer to the question arise during this year, on May this year, of the possible waiver of IP rights, maybe the answer is in the IP regime, the international IP regime, compulsory licenses and other flexibilities. This is my conclusion of this issue, and I would like to receive all your questions about this issue. Thank you very much.
Thank you very much, Dean Cordova, for that illuminating presentations. I would like just to remind that if you have questions, please put it in the section of Q&A on the Zoom. And right now, I would like to give the floor, at least this virtual floor, to Professor Zaballala for his presentation. Thank you so much, Professor Zaballala.
Thank you, Professor Morantes. This has been such a fascinating time. I think for many people like us, we almost get a sense of a deja vu when we are discussing this issue of access to COVID vaccines, because of course, many of these same issues came up in many similar ways around the issues of access to HIV medications. Now, they're both similar legal issues and similar structural issues, but I want to talk a little bit about both how this differs, where we are, how the solutions proposed differ and have learned lessons from that time, and what that suggests for what is going to happen going forward. So when we think about the debate about access to HIV medicines, in particular was antiretrovirals. And we were really primarily talking about what we think of as large molecules, new chemical entities, relatively easily described, relatively easily produced and replicated, I say, relatively easily replicated by those companies that would have some of the basic understanding of the underlying chemicals. And so in that context, the major pharmaceutical companies have patents as the primary mode of protecting their intellectual property. They control then the production of that. But one of the other things to note from that period of time is that the pharmaceutical companies from that period produced much of their medications in their home countries. So in Switzerland, in Germany, in the UK, in the US, they have production facilities there. So you have, I think that's a really different thing. So compared to COVID now, for example, the vast majority of production actually tends to happen in a dispersed production chain in India, in Germany, right, in Latin America. Different components are produced in different places and then completed maybe in the US, right? But you have a globalized logistical and supply chain, right? And these are produced all over the world. The other thing to note is with COVID is we're not dealing here with what we think of as large molecules or new chemical entities. We're dealing here with biologics, right? With mRNA vaccines, primarily for the Pfizer and Moderna, AstraZeneca as well. One of the things you're noting, therefore, is it's not really the patent, though the patent does matter, but it's also protected by trade secrets and know-how. And that knowledge about how to produce it is almost more important to the market control these companies have than the patent itself. And you can tell this because Moderna was very happy to say, we're not going to enforce our patent during this period. And yet somehow they still remain in control of the fundamental technology and are able to make record profits in the current environment. So that's one way in which you're dealing with a very different environment from the HIV situation. And that matters because the solutions around compulsory licensing were built around the presumptions of that experience with HIV medication. So one of the ways in which we solved the HIV medication problem was a market solution and then a legal solution. The market solution was this: India. Right? The market solution was India, right, had a huge generic industry which was able to produce generic versions of these products and could seek to export them both legally and perhaps maybe in ways that were not necessarily 100% legal to many developing countries in Africa. And there were firms in Latin America that did that as well, but also to Latin America. So there you had pre-existing, right, highly capable industries who were able to produce these products without any interaction or negotiation with the originator companies. They could compete fully and fairly on the market. And so what we needed to do, the solution we needed was a solution that allowed companies in India to produce for export to those countries that didn't have domestic manufacturing capacity. So Botswana, even South Africa at the time, Nigeria, Egypt, right? All these places. And that worked to some extent, right? So that was the legal solution. You have the legal solution which allowed for that kind of export to occur. But you also had a market solution, which was that after many of the pharmaceutical companies sued South Africa for trying to import from India, and they lost the public battle at that period of time, they pulled back and decided not to sue and decided that they would give that part of the market on HIV medication in Africa, let the Indian companies have that, as long as they were able to maintain their home market in the US and in Europe and even in Latin America and prevent parallel imports from there. So that was a market solution. But as Professor Marentis pointed out, there was a really good global solution in the legal situation in the WTO, where they had the TRIPS agreement, the amendment to the TRIPS agreement, Article 31, which enabled countries to produce for export and produce compulsory licenses for production for export. So now comes COVID. So problem number one is that you do not have companies in developing countries capable of producing this independently of access to the trade secrets and the know-how from companies like Pfizer and Moderna. So yes, you might have access to the patent. You can see it published, but that doesn't tell you how to actually produce it. So that means that most of the firms in those developing countries have no incentive as a market basis to try to produce without permission. They have neither access to the trade secrets or the know-how. And because they're part of the global production chain, they have an interest in actually being able to get the contract to produce for Pfizer or for Moderna or for Johnson & Johnson for their primary markets. And so you have firms in India, like the Serum Institute with AstraZeneca and Johnson & Johnson, producing not for the Indian market, but as a contract producer, working in tandem with Johnson & Johnson for re-export back to Europe while their own population is at the back of the line. You see this in South Africa. We have recently exported a fill and finish capacity where they send finished product to South Africa, the South African company fills, bottles and finishes, and then re-exports it back to Europe. So one of the problems is developed countries got to the front of the line. They bought up all the production and manufacturing capacity that Pfizer and Moderna and the others had. And now we have production in this global chain, but very little of it is going to deliver the needs of developing countries right now. Most of those developing countries are at the back of the line, likely to see only some significant vaccination rates in mid to late 2022, many of them in 2023, and for some, even 2024 for being able to get that. So that's a real problem for the market structure, which means that you have significant manufacturing capacity, but much of that is taken up for production to developed countries who have bought up and contracted the initial production lines. But there does exist unused production capacity. So there is the fact that even where Pfizer and Moderna have contracts, they don't transfer the know-how and the AI and the know-how and the technology to the partners. They work with them. They do very specific things in terms of production, but the Serum Institute isn't in a position to really have the know-how to produce for export, for example, or to do so independently. And that's true for companies that are not in those contracts as well. So that creates a real problem. How do you get the largest amount of production that you can get from this situation when you have these vertically integrated supply chains where only some people are producing? So Pfizer, Moderna, and Johnson & Johnson have a lot of contracts for production across the world, but that's not really technology transfer, right? That is, you are our contract manufacturer. But we don't have our other companies producing, right, so that they can compete on price and make it easier to provide to every single demander out there in the market the product that those people are demanding. Instead, we have a huge amount of production capacity taken up, and then a huge line of people trying to get in. Right? You can imagine Pfizer and Moderna could release into the public knowledge their trade secrets and know-how, but they haven't done that. Why? Because this gives them control of the market. Right? And so Fernando pointed out that the role and the reason the compulsory license exists is in order to break that market control, to allow for other production and for competition of price in order to meet the public health need that is out there. In COVID, a compulsory license for patents, which is what Article 31 is limited to, won't get you that. It simply won't get you there. That's one of the primary failures of the current system for dealing with COVID. And it's one of the primary arguments, right, that people have that, well, you can't do anything here. But what South Africa and India and other countries are proposing is a waiver, not just of patents. It's a waiver of trade secrets protection. It's a waiver of copyright protection for some of the AI that's involved. All the intellectual property necessary to produce it will be waived. And it'll be waived for a specific period of time. And that's crucial as well. I'll talk about that in a moment, right? But that's why the waiver is of such a large scope, that the current system that's developed for HIV is not fit for purpose for COVID. And so the proposal is a legal, temporary solution rather than a permanent solution to the problem posed by COVID, specifically of the global supply chain. Now, one of the reasons this matters, that we have this scope and this waiver, is that if you're going to convince companies to get in on this, you need to provide them with a real, viable, market-based incentive to get into the COVID production market. If you have what is known to can happen under the Article 31 system under TRIPS, where it can shut off at any point. It's unpredictable. It takes a very long time to get. Very few companies are going to invest in transforming their production lines in order to produce COVID vaccines in order to enable them to get into the market. And so one of the reasons this is proposed as a waiver is to ensure that countries can create sufficiently stable long-term market opportunities that there'll be enough incentives for firms to come in and use the know-how and the patent knowledge to produce and compete with Pfizer and Moderna and Johnson & Johnson, and to get these products to Nigeria, Kenya, South Africa, etc., and to get them there sooner rather than later. So if that's the case, then why are there objections to this? This seems entirely rational and normal, right? It seems to be built into the IP system that we should be able to do this. And the problem is we have to make a distinction between what we think of as the domestic IP system, which I think, as Fernando points out, is highly flexible, and the international IP system, which deals in cross-border flows, which is much less flexible. And that international market being much less flexible is crucial, because intellectual property protection is, of course, national, and that flexibilities and exceptions are national. But the obligations are also international, but the flexibilities and the exceptions are not. Right? And so this is one of the ways, the waiver is one of the ways to try to embed the idea and the idea of broad exceptions for emergency needs like public health into the broader international intellectual property system, but to do so also specifically for this particular COVID environment. So the US has said they support it. I am as surprised, I think, as many people were that the US chose to support it. But the EU in this situation does not. And the EU has several objections. The primary objection is they don't think it'll have any effect. They say, well, you can have a waiver, but nothing's going to happen. Right? By the time you have the waiver, you negotiate it, you figured out exactly how it's meant to be implemented, and then it's implemented in your national law to allow it to occur. Right? All we can agree with at the WTO level is not to take WTO cases against each other, but that doesn't stop Pfizer in Argentina suing under Argentinian law for its protection under Argentinian law. And I think that's in essence correct. But on the other hand, that ignores when this idea of the waiver first showed up. Right? It showed up in the early period of 2020, right? January 2020, when if we had agreed on that at that time, Now we'd be in a position to be implementing it, and then we'd be having much larger access over the next 2 years to the vaccines. And so this idea that, well, it's too late now, nothing's going to happen, ignores the amount of time it took for those countries to even consider it. And it ignores one other fact, which is right now, for example, Europe and the US are going to be implementing boosters. So that means not only are they going to require and contract for existing manufacturing capacity, they're going to then take more future capacity out of the system, leaving developing countries again further back in line for ordering from these companies. And so a waiver, right, can go a long way to dealing with this issue, not just in 2022 and 2023, but in 2027 and 2028, when those countries will need boosters. And so at whatever point we are going to put this in place, given the time frame that we are likely dealing with in terms of COVID, and given the fact that many developed countries are going to continue buying up significant chunks of the supply, we need more manufacturing capacity to do that, and the waiver is a way to get there, because Pfizer, Moderna, and Johnson & Johnson are not going to do so voluntarily. There's no rational reason why they should do so voluntarily. They have fundamental control of the market, and they're producing to the fullness of their own capacity. And so the question that arises is, they could license voluntarily, and they're not doing it. And so they need an incentive to do that. And one incentive to do that is to threaten them with loss of their market control, unless they go ahead and license to lots of other people and are getting paid to do so on their own terms. Otherwise, under the waiver, they won't even have the right to remuneration. So that's argument one from the EU. I'm going to close off and then leave some questions for everybody else. Argument two from the EU, I think, is more specious, which is that intellectual property isn't a problem here. It's manufacturing capacity. There just isn't enough manufacturing capacity. There aren't enough inputs. That's really where the bottleneck is. That if we take care of the inputs and those bottlenecks, that Pfizer and Moderna themselves will be able to expand their manufacturing capacity and meet all the needs that are out there. And I think the input issue is correct, right? I have a colleague, Chad Bown, who works at the Peterson Institute for International Economics, who's done some great work on this. But it's not the only problem, right? The argument that it's not this, it's that, ignores that, no, it's both. It's both a supply, and in fact, big chunks of the supply chain of inputs are also protected by intellectual property and patents and trade secrets. And we need to extend that to those products as well to increase their production. But that idea that it's one thing or the other misses the complexity of the problem, which is that it is partly market control, it is intellectual property, it is also inputs and trade. And those are the things that we need to do. And so the intellectual property bar, the intellectual property system is one place that can contribute to meeting the need here of COVID, but so does the trade community and the trade legal and policy system and the health legal and policy system and the human rights legal and policy system, right? All hands are on deck. We don't get to say, this part isn't a problem, let's not do this. And I'll open up to questions and appreciate my co-discussants for really setting the table for me to be able to not have to talk about some of the more deep and detailed issues.
Thank you so much, Professor Shabalala, for a wonderful presentation. I would like to request the persons who are attending the webinar, if you have questions, please post the questions in the Q&A section of the Zoom. I wonder if, in the meantime, Professor Shabalala, you have any questions for Professor Cordova, or the other way around, if Professor Cordova has some questions for Professor Shabalala. If no, I got a question here from Catalina Gomez, which is the following. Speaking of a pandemic and global health at risk, shouldn't there be a leadership from organizations like the WTO to encourage the relaxation of intellectual property measures on vaccines? What can the role be of the international community here, or for future cases? We will continue at the will of the producers? Then I wonder if first maybe Professor Chavalala and then Professor Cordova would like to say something about this question.
So, Professor Cordova, you are as familiar with the limitations of the WTO system as I think I am. So there is this proposal on the table at the WTO. It has taken a long time to get to the point where it is actually being negotiated as language. And they use fairly simple language. It's unusual for an international proposal that it's only 1 page long. So there is this discussion at the WTO. I will say that I am pessimistic that it will survive in the form that it currently does. I have always believed that it is more likely to end up in some form of the same type of compulsory licensing solution that Professor Cordova was talking about, but with, I think, slightly broader in scope and simplifying some of the problems that we saw in the Doha Declaration, such as creating sustainable and predictable markets and reducing some of the length of time it takes to get a license and things like that. So that is where I think it is likely to end up. The EU's counter proposal that exists right now is essentially, why don't we just do Doha? And I think that's not a sustainable solution either. So I think we will probably end up there, but I don't think we're going to end up there before, I don't even think the end of the year. Professor Cordova, I mean, that sounds probably too optimistic, but I don't think we're going to get there even before the end of the year. At which point then you'll have countries have to do national things. So I think we are going to have a solution. I think it would likely be much less effective than we think it actually is. And my preference would be for the WHO to take a stronger lead on this through several of its existing mechanisms, COVAX and the ACT Accelerator and several other mechanisms for sharing technology, but they have no teeth. Right? And the reason people go to the WTO is because they think the WTO has teeth. And I am not someone to advocate law breaking. Carlos, you heard me, right? I'm not one to advocate law breaking. But I don't think, ask me if I think that if a firm in China managed to get a hold, China or Indonesia, the Philippines managed to get a hold of the know-how and the trade secrets and produced it and exported to Kenya or Nairobi, that the US or the EU would bring a case to the WTO. And I say, sure, let's see if they really, really want to be seen as the people preventing people from dying in those countries. And so I am an advocate of saying, take a unilateral action and then let us see if they bring a case. The problem is finding 2 countries to cooperate on that. And the problem is getting access to the know-how and the trade secrets. And I think that is really the primary barrier.
Excellent. Thank you so much, Professor Chavalala. That was a wonderful and very provocative response. Excellent. Now, Professor Cordova, please.
Thank you for the question. And I agree almost totally with your view, Professor Chavalala. I think it's very difficult to get WTO very involved with this issue, although I think there is a huge international pressure in order to get a flexibility to produce the COVID-19 vaccines.
Mm-hmm.
For that reason, maybe I propose in my presentation that the way, maybe the fastest way is through international human rights courts or organizations, because there is a evident, it's very clear conflict between these private economic rights, IP rights, and of course, human rights, health and life rights. And maybe there are some cases in international human rights courts dealing with patents issues or with IP issues, and sometimes they have a different view that, of course, WTO panels of experts or national courts. So maybe the way or the role of leadership that Catalina is asking, maybe it's through international human rights organizations, United Nations, for example, the Office of the Human Rights of the United Nations Commissioner. Yes, thank you.
Professor Shabalala, would you like to say something else?
I'm curious about this issue of human rights. So the Dayton is going to be holding the biannual social practice of human rights conference this semester, and I'll be putting together a panel on human rights and COVID. And one of the things that I think was actually quite successful, right, was that in response to the HIV crisis, we pushed for human rights bodies to first address themselves at the country to say, you have an obligation to meet the medical and public health needs of your population. And then to go to Europe and America and say, you have an obligation not to interfere with those countries' attempts to meet their obligations to their countries under Article 2 of the International Covenant on Economic, Social, and Cultural Rights. But, and then you have the Inter-American Court of Human Rights, you have the African Court of Human Rights, you have the European Court of Human Rights, all of whom have in some version ruled or done proposals or general comments around this. How successful do you think those institutions are going to be in the COVID arena? I think they've been relatively successful in changing the conversation around HIV and access to medication, but not necessarily around TRIPS more generally. Do you think there is likely to be success in how they address it under COVID?
I wonder if Professor Cordova would like to reply to that question, or it was not a rhetorical question.
It was directed to Professor Cordova. Yes, please.
Yeah, I don't know, Professor. It's very difficult because, yes, there are different systems of human rights in the world, so it's very difficult that the European Union decides to help poorest countries in Africa. But I think they have the conscience of their responsibility with the world community in order to control the pandemic, because this pandemic is a problem of all of us, not just you maybe can close all the frontiers in Europe in order to control or to prohibit the entrance of foreigners, different countries, but I think that is not the solution. Maybe if we can ask for solidarity from different countries and apply universal human rights standards, yes, we can get a better solution in order to get all these license faster in order to produce locally the vaccines for COVID-19.
Thank you so much. I think this dialogue is amazing, concerning particular 2 points, which is first, the tensions between the different fragments of international law, the different fragments, on the one hand, the human rights systems, and on the other hand, the international economic law systems, and how those systems, they don't dialogue, they don't enter into in dialogue. But then we have also the relevance of maybe the domestic courts, like for instance, in the case of HIV, I know Professor Shabalala should know all the history behind the TAC case, the case of the HIV case in the Constitutional Court of South Africa. And also there is another similar decision in the Supreme Court of New Delhi, in which in both cases, the holding was that the medicines should be made available to the people despite of the price, or regardless of the capacity to pay for the price. Now, I do think, if I may say something here, that this is one beautiful point in which we see the tensions of those systems, the tensions between the principles and rights in collisions in here. But as Professor Shabalala said, there is another point concerning, the real politics here, or in the politics of international law. Maybe there is a country that would say, we are in rebellion, we break the rules, we don't pay for the right, and then who's going to take those countries to a panel within the framework of the WTO? This on one hand, and on the other hand, for instance, thinking about the Inter-American system, there is a rule according to which all the Inter-American standards that are included in the reports of the Commission, they are binding law for the countries, at least in theory, and the countries, they should comply with them in good faith. Then on that basis, that could be internal litigation that can lead, for instance, to a constitutional court or a Supreme Court to declare that the vaccines should be provided free, and also maybe at the end a case in which the Commission or the court could say that this could be the case. We don't know about that, but those comments on those topics are really illuminating. Then I wonder if somebody else has questions. If this is not the case, then maybe I would like, Diego, please.
So I am a cynic about the US support, Professor Cordova, because, I have been involved in many international negotiations, and I have seen the US at the CBD be highly involved in the negotiations, and then come back home, try to get it approved by the Senate, and they don't get it approved. In the meantime, they spent years diluting and diluting, telling us, only if you dilute it to this level will we be able to get agreement at home. And then it turns out they can't even get agreement at home on that. We saw that with international law, Convention on the Law of the Sea, right? United Nations Convention on the Law of the Sea. We've seen that with climate change negotiations. Over and over again, ambition is diluted to accommodate the US, who maybe are actually negotiating in good faith. I do not want to say that about the negotiators, but who constantly misjudge the capacity at home, domestic capacity, to actually come to agreement on this. And it strikes me that that is where we are likely are with Thai and COVID. But I wonder if that is also true for other countries. So one of the areas I am particularly, Brazil, right? Colombia, Latin America, right? Who are ostensibly in the Geneva group, working with South Africa, et cetera. But when it actually comes to implementation of anything there, you have a very different domestic environment for that. And so even with the Doha Declaration, how it was implemented in Latin America is very different from how I think other people envisioned it would be. Right? Do you think there is a big domestic interest and domestic political will in Colombia or other Latin American countries for what the waiver is proposing, or do you think there are sufficiently strong counter proposals or counter wins that they would likely either not adopt it or implement it very narrowly?
Yes, thank you. Very interesting your point, Professor Chavalala, because I have seen in past negotiations that Colombia's position has been very supportive for intellectual property rights. And of course, IP owners' lobbies in the Senate and the government in Colombia is very strong. However, President Duque, Colombian President Duque, stated 2 weeks ago that our country is ready to produce vaccines, COVID-19 vaccines domestically in our country. I understand that they have had some conversations with China's companies and other producers, and maybe that's the final answer. All the competence between companies in different parts of the world, maybe they can offer at the end better conditions to produce domestically vaccines in every country. And maybe that's the case for Brazil or South Africa. They actually have the capacity to produce all these vaccines in their countries. But I remember another statement of some analysts about this production of vaccines is IP rights is just a portion of the price of the vaccine. There is a huge portion or different price for production and distribution. Maybe there was a disclosure of the prices of vaccines in Colombia a week or 2 weeks ago, and we knew that Pfizer vaccine, every dose costs $12 for Colombia, and AstraZeneca vaccine $6. But maybe in those $12 of Pfizer vaccine, maybe just $3 or $4 are IP rights. Production and distribution, remember that they have to have special conditions with temperature. Maybe it's very, 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 very high in the final price of every vaccine. So yes, I agree with you that maybe it's a political statement from the government, the United States government, that they are going to support all the waivers in WTO for COVID vaccines. But at the end, it's going to be very difficult to get a majority declaration, to get another Doha Declaration for COVID-19.
Maybe following up a little bit about all Latin American countries, one place in which I would say the proposal for the waiver is resonating a lot is the Caribbean islands, because they have been unable to access the vaccines because of financial difficulties and also logistic difficulties. And really, those countries are struggled because the islands are closed, no tourists are going, the jobs are gone. So I think they are in a hurry, in need to get desperately the vaccines. And the other point is that if the need for boosters is there, then there is going to be increasing pressure in getting the vaccines, regardless of the financial possibilities of the people and the countries.
And I think also, sorry, I think we have limited time. Let me just.
No, we have time. We have time.
I think the point also is when the waiver happens and it's a waiver of trade secrets and know-how. Which country is going to be the one that enforces the company to say, you must now share your trade secrets and know-how? It's not going to be the importing country. It has to be the exporting country, which means it'll have to be the US government telling Pfizer, you have to now share this with this company. Right? It won't be South Africa saying, we are going to now say, yes, Pfizer, you must share this with our South African company, because under what you might even have some jurisdiction, but what penalty, what regulatory framework do you have for doing that? If all they're doing is exporting your country, they won't have domestic assets or anything like that in your domestic arena, right? Same thing with India, right? And so the problem I think that I see is the waiver passes, the US says, yeah, but we're not going to actually force our companies to share their technology, their trade secrets and know-how. In fact, that's a violation of our domestic law, right? And that'll be true in Europe as well, right? And so the question I think is going to be, do we see already, despite their support, do we see them telling the companies, you must cooperate with these other companies? We saw them do that, right? Here in the US, the Biden administration forced Pfizer, Moderna to cooperate with another American company in order to increase the capacity and to share resources around the inputs into the production, right? They sat them down, they put them in a room in the White House and said, you do this, or, we will find legal ways to make you. And they did that. You'll notice they are not doing that for production for developing countries, etc. And so for me, that's where the rubber hits the road. That's what they're going to have to do in order to make a waiver effective. And we don't even see them beginning to do that now, let alone providing some kind of legal framework that they're then going to have to pass that will be implemented in the US that will allow them to force their companies to provide access to trade secrets and know-how under US domestic law or EU domestic law.
Yes, I agree. Actually, I do see some Latin American countries telling the companies, I want your trade secrets and know how to produce my own machines. But I don't see any company, I don't see Pfizer telling them all its trade secrets and know-how.
Yeah. Right. And this is, this is one of the things we are discussing with many countries right now, which is this may require coordinated action. And one of the areas that we point to is in competition law, we see coordinated action across countries to enforce antitrust, including around intellectual property issues. This may be an area where some mechanisms for that kind of thing around public health, where there is a coordinated demand from a set of fairly large countries, so Brazil, India. I don't like to say China because the moment you say China in the US, people freak out. So Brazil, India, South Africa, right? Philippines, right? If those countries get together and do a coordinated action through either the G20 or some other mechanism where they state that we are going to issue this kind of license for trade secrets and know in all these countries, and they present significant markets and assets of these companies, then I think you're in a position to maybe pose a threat or danger that they feel like they need to comply with. But absent that, I think, it's going to be very difficult for South Africa alone or the Philippines alone or Colombia alone to do that. I think, and so.
One point that I see here difficult is that after if that were the case, and let's imagine the waiver is successful and is passed, then the next that's a precedent that can go into a slippery slope concerning not all IP rights of other vaccines or drugs, like for instance influenza. Every year, how many people die from influenza? Then why COVID yes and influenza no? And then the right to health has the equal weight than the right to education. So what about the rights of the students that they cannot access technology in their house in poor countries? Then what's the reason for those people not to have the access to Apple technologies, etc.? Then that's a key issue. That's a tricky issue.
But Carlos, you have found out my secret plan. I mean, that is the fear, right? That is what we hear from the EU and others, that where is the line? If you can justify it for this, you can justify it for anything. And so that's a difficult argument for me to make, because I'm sitting there thinking, but this is a once in 150 years disaster emergency. If you cannot be flexible for this, what will you ever be flexible for, right? So I turn the argument the other way around, which is, okay, look, we know there are limitations, we know there are lines, but this seems like the easiest possible case. There's a worldwide global pandemic. Everybody needs it. Lots of people are dying and everybody's affected. This should be the easiest case for you to say, okay, maybe we'll be flexible in IP for now. And if you can't be flexible now, is there any situation you can imagine under which you will be flexible? And we can argue about where the line should be, but I feel like this issue is a long way past the line that we need to worry about, right? I'm willing to do some slipping on the slope for a little while to deal with this issue, right? But I think that is a real concern, but I think there can be an argument about where the line should be, but I don't think there's an argument that COVID is on the side of the line that we should be worried about. Yeah.
I think maybe one interesting place in which this discussion and this interlocution between human rights and international economic law should take place is Strasbourg. If by any way this goes into a case to the European Court of Human Rights, then that would be interesting, because they have to, on the one hand, observe, depending on the country, observe the European Union regulations, and on the other hand, they have the EU human rights law, the European system of human rights, and that should be interesting to see how they can solve this. Okay, I wonder if somebody else has another question. If no, then I would like just to take a couple of minutes to give the floor to Dean Strauss again. And then if Luisa can prepare just to talk about the online LLM program at UD. Please, Dean Strauss.
So before I start, I did have a question. Maybe I could just ask. Can you imagine either Juan Fernando or Jebo, a way in which this could be adjudicated by the International Court of Justice? Is there any way that some of these issues could be resolved at that level?
So I remember this came up under the HIV discussion as well, which was, what would be the jurisdictional hook for the ICJ? Right? And, you know, we decided probably it would be sort of an appropriation case, potentially. So in the absence of an international investment treaty between the two countries that are involved, right? So without a pre-existing jurisdictional allocation, then it would be, you know, especially if it was and this is where it gets complicated, if it was a government entity whose intellectual property was being taken. So for example, let's say Sinovac and is a government entity and it was being taken by Brazil, then that might provide sufficient jurisdictional hook to think about this as sort of expropriation
Under a bilateral investment treaty or something.
What after the bilateral investment treaty, it might end up in the ICJ. With a bilateral treaty, right, because there's sort of a broader base jurisdiction for, so if both countries are members of the ICJ of the treaty and have agreed to its jurisdiction more generally, then this might be a place to bring it. But we never found it a strong enough hook.
I was actually thinking of the opposite situation where, in order to legitimize a country actually doing some sort of intellectual property infringement, that first you would get a case before the ICJ before doing that, and then that would be the legitimate basis for legitimizing the action.
So you're thinking advisory opinion almost?
I mean, that would of course be possible if you got the General Assembly to request an advisory opinion, or the WHO, maybe the WHO could do that.
Yeah, that's what, I mean, that was, I think, as far as we got, which was getting a General Assembly to seek an advisory opinion. And there was a movement at the time before the WTO got the Article 31 solution together to get the General Assembly to perhaps make a request to do that. But it was easier just to go directly to the Office of the High Commissioner of Human Rights and get a special rapporteur put in place to get a general comments done, right? Which then enabled the courts in South Africa and in thing to then use that as a basis for their domestic decisions. And so I think that felt like a much stronger case, but it only worked also because the US companies lost their case terribly against South Africa. It was such a disaster that they were burned. They never thought they would do it again.
Maybe the way to go to the ICJ in an individual case would be a diplomatic protection case. If absence an international investment, bilateral investment agreement, because if there is a bilateral investment treaty, then probably that will go to the exit, and that would be solved by means of an arbitration panel.
Yeah. And because all those panels have final authority, there'd be no appeal process of any kind to any other body. So yeah.
Well, good. Thank you both. This was really this was fascinating. Great discussion. I learned a tremendous amount. So my task now is just to talk a little bit about for the participants from Sabana, La Sabana, is to talk a little bit about the University of Dayton online LLM degree that we have as part of our partnership with the dean and the university in La Sabana. And I think Luisa Maria Lozano Diaz is going to talk a little bit about this as well, who I know has been a very good partner of ours in all of this. So in LLM, many of you probably already know that an LLM is a master's degree, a postgraduate degree in law. And we have had an LLM degree for quite some time, but starting in 2019, we began to offer a fully online option. We're one of the few American law schools that actually has a fully online LLM degree in normal times outside of COVID. So you don't have to travel to the United States. The degree can be pursued entirely online. And in addition, we offer becas to make the degree affordable. And we have an agreement para becas especiales con la Universidad de La Sabana para ustedes, para los estudiantes de esta universidad. Y por eso es uno de los más baratos títulos que se puede conseguir de escuelas de derecho de los Estados Unidos. Part of this, what I always refer to as the value proposition, is that uniquely, if you pursue this degree, you can do it while you're a student at La Sabana. And we will accept up to 10 credits from La Sabana. So for relatively few additional courses and a relatively modest additional cost, you can actually get 2 degrees, your undergraduate degree from La Sabana and your master's degree from the University of Dayton at the same time. So you can really graduate with 2 degrees for roughly the time and the cost that normally you would get 1 degree. And of course, that will then allow you to take a bar exam in the United States. You can actually be qualified to practice in the United States. We've worked it out with the state of California and the state of Washington State on the West Coast. That you can take their bar exams, and it looks like this is also going to be possible in Washington, D.C. So these are, of course, major bar exams in the United States. You can complete it in 1 year or less. It's 12 courses if you were to do all the courses. This semester, you have to apply very, very quickly for this coming up term. It starts August 23rd, but then the next term is starting January 11th. And currently, we've been growing really rapidly. Currently, we tenemos 84 estudiantes de todas partes del mundo. Y la mayoría de nuestros estudiantes trabajan o están estudiantes en universidades. Y para ustedes se pueden ganar una experiencia con el derecho común de los sistemas tienen origen de Inglaterra, y y también ayuda en una práctica transnacional, y van a tener van a entender los básicos del sistema americano si ustedes hacen esto. Para más información, si ustedes tienen interés en esto, se pueden contactar a Margaret Ioannidis. Se llama Margaret Ioannidis, y su dirección de email es MIOANNIDIS, el símbolo de número 1, at Dayton, UDAYTON.edu. Margaret Ioannidis is MIOANNIDES 1 at udayton.edu, or Walter Haas at WHAWES 1 at udayton.edu. Y los dos hablan el castellano mucho mejor que yo. O ustedes pueden visitar nuestro sitio de web at go.dayton.edu/online LLM, or just put Dayton LLM, University of Dayton Law School LLM into Google. So muchas gracias, y back to you, Carlos.
Thank you so much, Dean Strauss. Now I would like to invite Luisa to address the audience. Luisa, por favor.
Thank you, Professor Bernal. First, let me say that this was a very interesting webinar, Professor Cordova and Professor Shabalala, dealing with a very relevant topic today due to COVID-19, but I'm sure that from now on, this is going to be part of the public and private debate. And also, this is something we need to address and to put in the international agenda. So thank you for that interesting discussion. At La Sabana, we are really excited about this academic collaboration between our universities. This is a collaboration which is very recent, but now extends to student mobility as well. This semester, we have some students starting their online LLM program at Dayton, and we hope to have more students every year. And because Andrew explained so well the program and our partnership, I just want to take this opportunity to invite La Sabana students who are still with us today to explore this possibility of articulating their undergraduate studies, you know, the law school, with an LLM in the United States. And why not? Do it with the University of Dayton. We already have the agreement. We have all the tools to support you. And from my side, I'll be ready to answer all your questions and help you with the application. Trust me, this is a very simple process, thanks to the wonderful staff they have at the University of Dayton. So please don't be shy. Write me an email or contact me through Teams. I'll be happy to help you. So this is it. I think we are on time. So thank you so much for this opportunity, and it was nice to see you all.
Thank you so much, Luisa, for these kind words. And then if there is nothing further, then I would like just to thank everyone for being tonight with us. Muchas gracias a todas las personas que se conectaron desde Colombia por estar aquí con nosotros, a nuestros dos estupendos presentadores. Y quisiera invitarlos a las próximas conferencias que habrá en esta serie de webinar de Latin American Engagement o Law in the Americas. Tendremos por lo menos dos que son muy relevantes para Colombia. Uno es sobre el derecho a la protesta, the right to protest, y luego tendremos uno el 22 de octubre sobre Uber, sobre los derechos de Uber, y tendremos dos maravillosas personas que presentan, mi colega Pamela de Dayton y un profesor de la Universidad de Uruguay, Federico Rosenbaum, que discutirán sobre este tema. Así que en la página web está toda la información y espero poder verlos en futuras ocasiones. Muchas gracias y entonces pues quedamos en contacto. Thank you so much for everyone. Have a great evening.